The next time you need a haircut, think of the barbershop with a grand tradition. Williams Barbershop. Williams Barbershop, proud to serve the entire community of Eufaula. Come by to our new location, new facilities, and see what it's like to be treated in style at Williams Barbershop in the old JCPenney catalog store. There is another choice for making funeral arrangements. Central Funeral Services, located in Eufaula and Louisville, Alabama. With one-of-a-kind staff, thrives on professionalism and meeting the unique needs of families with a wide variety of services. Owned and operated by the Mixon family. Call 687-1060 or 266-5261. Melissa Mixon Smith, licensed funeral director.
Good evening. You're watching Gumbo Live, and I want to thank you as always for watching. And you're watching either on local TV channel 97 on Tuesday nights, or at 6:45, or you're watching us on YouTube from everywhere. Say hello to all my friends in Louisiana. I got with me our judge here in the circuit judge.
That's right.
Presiding circuit judge here of Barber and Bullitt County.
That's right.
So he's very busy, and I want to thank him for taking this time out to be on Gumbo Live. We are here in this beautiful office. You call it a study office?
Well, it's a office, and it's a hearing room for hearings that we have to have in private. You know, if a hering involves a minor or something, we can't have that in the courtroom, so we'll move down here.
All right. It's very beautiful, very beautiful. Now, what I want you to do, Judge, I want you to tell our listening audience, who you are, something about yourself, and how long you've been serving and things like that.
All right.
This is Judge Smithhart.
Hello, everybody. I'm Bert Smithhart. I'm the circuit judge for the 3rd Judicial Circuit. That's Bullock and Barber counties. I live over in Union Springs. It's where I've raised my family, and it's where I'm originally from. Moved back there after law school. Practiced law for about 10 years before I ran the first time. Was elected in '98, so I've served almost 20 years, or 18 years at the end of this term. I have 2 children, Wesley and John. My daughter Wesley's a senior at Huntington College in Montgomery. Okay. My son John's a senior at St. James High School in Montgomery. I think he's planning on going to Auburn. I know that'll be a shock to everybody. And then my wife Elizabeth is a lawyer, and she practices in Union Springs, but she can't practice in front of me, so she does other things in other counties and other places.
Just let me tell you how I operate. As you see, there's nothing in front of us. You don't have any notes. I don't have any notes. A lot of times you may say something, and I may cut you off, because you may trigger something that I want to ask you a question. I'm not trying to be rude. I don't want to be contempt of the court or anything. But what I try to do, I try to inform our audience as much as I can with the time that you have allowed me. And I want you to know I really appreciate your time. Now let's talk about this. You are elected. You are elected. How you feel about judges being elected?
Well, I believe that judges, just like anybody else in public service, need to be accountable to the public. And the election process is the best system of accountability that I know. Mm-hmm. There's been a movement over the whole time I've been on the bench to maybe go to some kind of election system that only makes judges subject to recall as a nonpartisan candidate, something like that. That's never come close to passing in Alabama, so I've never really given it a whole lot of thought.
Well, let me ask you this, Judge. If the judges have to be elected, and how we get politics, because politics can be nasty, it can be partisan, it can be not, and you don't necessarily, everybody not as good as you. You don't necessarily you may not necessarily get the good judge based on party. So how do we, and let me say this before you ask that. Do you believe that justice is blind, or do you think sometimes he might pull up that little patch and look at it?
Well, justice is supposed to be blind in that whoever comes before the court needs to be treated the same. It needs to be the court's, my job as a judge is to make sure that people's rights are protected, that their constitutional rights are, that they know them, and that they know that those constitutional rights will be protected by the court. In certain types of cases have certain obligations from a judge's perspective that I have to be sure to watch out for the rights. It's the difficult part becomes when you're running and you've got political allies or adversaries that appear before you in court.
Now, do you have to, when you're running, do you have to declare a party? Like anything else?
In Alabama, you do have to declare a party. Now, a lot of states have gone to nonpartisan judicial elections where you don't declare.
Wouldn't that be better? If we're going to put politics in it. If we're going to put politics in it, which it seems like that's what's happening, would it not be better if a candidate can run and just not declare a party?
It probably would be, but you know, in Alabama, that would have to be changed by the legislature. And you know, I am a Democrat, and I've always run as a Democrat, and will always run as a Democrat if I'm given the choice. That's where I, you know, comfortable. I'm more comfortable politically.
Now, let me ask you this here: once judges all across the state get elected, how much influence or can I use the word power do you have so far as the legislation, so far as taking stuff before the legislation? Do y'all have a lobbyist party?
We do have a lobbyist, and the circuit judges and district judges associations have proposed nonpartisan elections. I think every year since I've been on the bench. It's always been in conjunction with other bills and has never passed. And so I don't see, in my time, I don't see that ever passing in Alabama, to be honest with you.
Well, and so that would be left up to the people. But let's do this. Most of us don't have an idea of how the system works. Okay. All of us think we do. And when something happens, we say, oh, you know, somebody was paid off or whatever kind of stuff like that. I want you to tell us two things, Judge. First of all, I want you to give us a quick overview of the grand jury system. Okay. Now let me say this to you before we get to that. We've got two judges in this courthouse.
That's right.
You and Judge Horn.
That's right.
You the man.
Well, I'm the circuit judge. Judge Horn is the district judge, and we hear different kind of cases. Okay. And then I hear appeals from his court too, and then an appeal from my court goes to Montgomery, to the Court of Criminal Appeals, the Court of Civil Appeals, or to the Supreme Court.
Okay. So you can hear appeals from Judge Horn court, but Judge Horn can't hear appeals from your court.
That's right.
Okay. All right. Okay. Now give us the elementary.
Okay, and let me say this, Reverend, you and I talked about this before we turned the camera on. I don't give a lot of interviews because there's so many things I can't talk about. I can't talk about any specific case or any specific defendant or any specific divorce.
Right.
You know, I hear cases that are made, by and large, felony criminal cases. Domestic cases that involve children and domestic issues, divorce, and I hear civil cases in excess of a certain amount of money. And all of mine, except for divorce, are jury questions, jury trials.
Let me say this. First of all, I want to say thank you for giving me this interview.
Sure.
But now, when you said domestic, my ears went up. That include domestic violence? Do you have domestic violence cases?
It does include domestic violence. Now, domestic violence can either be a criminal case or it can be a civil case as part of a divorce or part of what's called a protection from abuse. So, you know, I hear those in both sides.
My last program, I had Detective Bradley on to try to explain to us about domestic violence, because, you know, that's what's in the news now.
That's right.
Now, what about this case with Adrian Peterson when he whipped his child? Would that case come to you or Judge Horn?
It probably would go to Judge Horn if it happened in Barber County, because it could be brought as a neglect or an abuse case to a child. Now, if it was claimed of a felony abuse child abuse, then it would come to me. But if it was misdemeanor or a child in need of supervision or a delinquency case, those go to Judge Horn.
Okay. Now let's get back to I want you to give us the elementary version of the grand jury, but I got another question before we get there.
Okay.
All you hear is jury trial? Are all your cases by jury?
They are except for domestic cases. Now, divorce cases in Alabama are not tried before a jury. They're tried in front of a judge in a bench trial. But all felony cases are jury cases. Once they leave the grand jury and come up to my court, they're jury charges. And the same with civil cases, unless they waived a jury demand, or unless it's like a workers' comp case or something like that.
Okay. Now, Judge Horn does not hear jury cases.
He does not.
Okay.
Now, every now and then he'll hear one if I ask him to, just because he likes getting the experience.
Okay. So where we are now, we're at the grand jury. So when they leave the grand jury, they come to you.
That's right.
Okay.
If they're indicted.
Okay.
If there's an indictment.
By the grand. Okay. Tell us about being indicted. Tell us how to get to you.
Okay.
Judge. Would you do that, please?
Say there's a claim of a crime being committed, and the district attorney would take that case after an arrest. He would take that case to a first appearance in front of Judge Horn, where Judge Horn would explain what they're charged with, make sure they've got a lawyer, make sure they understand what the charges are, and then he would ask them how they wanted to plead, guilty or not guilty, and then it would go in front of Judge Horn again for a preliminary hearing.
Okay.
And this is normally how it's done. Now, some cases can go directly to the grand jury. That's up to the district attorney.
So before he get to the grand jury, it goes to Judge Horn maybe twice.
That's right.
Possibly twice.
An initial appearance where they make sure they've got a lawyer, explains to them what they're charged with, sets their bond, appoints them a lawyer if they need one, and then they come back for a preliminary hearing where Judge Horn decides whether there's enough for that case to go forward to the grand jury.
So are we safe to say this? Every case that comes before you, Judge Horn has heard it? Is that possible?
By and large, that's true. Now,
Okay.
the DA does have the prerogative of taking cases directly to the grand jury if he wants to.
Without Judge Horn hearing it?
That's right.
Okay,
That's right.
okay. So let's get to the grand jury.
And that's really based, Reverend Green, on timing. Usually, if the DA does that, it's because there's not enough time, or there's not a preliminary hearing date in front of Judge Horn before that next grand jury. See, in Bullock and Barber counties, our grand juries only come in once every 6 months.
Okay.
Once every 6 months in each courthouse, Clayton, Eufaula, and Union Springs.
Right.
So the DA will hold all the cases that are ready for grand jury until that next grand jury comes in.
Okay. All right. So now here we are. Here we are. Then went before Judge Horn maybe twice, and now he recommended to the grand jury. Who recommended to the grand jury? I'm trying to get to the grand jury so you can tell us about that.
Say Judge Horn hears the preliminary hearing, and he says, okay, this case is bound over to the grand jury.
Okay.
Then it goes into the grand jury whenever the next grand jury meets.
Okay.
And the DA presents that case to the grand jury. Now, the grand jury is drawn by me at random from a pool of jurors that has come in for civil trials, when we start a civil term. So I'll choose 18 random drawings. They'll go down, and that's the grand jury. I'll go down there and charge that grand jury, tell them what the law is, tell them what their jobs are, and swear them in.
Let's do something.
Okay.
Let's do something here. Let's be very clear.
Okay.
You randomly draw. You don't say, okay, you grand jury, you grand jury, you grand jury.
That's right.
You randomly draw.
What
So
I
when
do
we
is-
use words like select, we're gonna make sure that.
Yeah, it's called selecting the grand jury, but I don't get to select them. I
Okay.
have to do it at random. And a lot of times the way it's done is we'll have the whole panel in. There'll be 150 people in the jury room, and we'll do what's called general qualifications, where I swear them in, and I ask them general qualification questions like, are you over 19? Are you a citizen of the United States? Are you a resident of Barber County? Are you related to the DA or the DA's employees? Those kind of things. And so then we have general qualified panel, saying there's 100 people in that panel.
Okay.
a lot of times I'll say, okay, to the clerk, Mr. Nix, I want you to draw out, starting with juror number 1, every 5th juror, and that'll be the grand jury, or every 3rd. Or sometimes we'll cut up the slips of paper and put them in a hat and draw them out one at a time.
When somebody walk in, they don't know whether or not they're gonna be on grand jury or not.
They don't.
They don't know.
They don't know.
But now, once you pull out the number, everybody that's in there know who's gonna be on the grand jury.
Well, I explained to them that the first thing we'll do after qualification is we'll pull a grand jury, and that means whether it's every 3rd or every 5th or drawn out of a hat, I'll call those 18 names, ask them to go downstairs to the county commission room, and I'll be down there in a little while to start the grand jury process.
So once you pull out the number that you need, you separate them.
And it's always 18.
It's always 18.
It's always 18.
It's always 18, so they're immediately separated.
That's right.
Okay? Now let me ask you this here.
Now they don't know at that point, they don't know what cases they're going to hear.
Okay.
They don't find that out until they get into the grand jury room.
That was my next question. But look, I read here recently about a special session of the grand jury being called. Now you explained to us very well about how the DA and Judge Horn does with time-wise.
Right.
Now how do we get a special? What is that?
If something happens during the time when a grand jury has been recessed before the next one's coming in, the DA can request a special grand jury. And I guess over 18 years, I've had that happen 2 or 3 times at the most.
Really? Now that's money. That's money though.
That's right.
Very, very expensive.
It costs money.
Okay.
And you bring the grand jury in, you bring a new grand jury panel in, and you select at random a new 18-person grand jury, and you recharge them, and they start hearing cases or a case, whatever the situation.
Okay. So the people that served, let's say they served yesterday on the grand jury, and then a month later you need a special grand jury. You don't call these people back.
You can call the recessed grand jury back in, or you can impanel a new grand jury, and that's the decision I have to make.
You make that decision.
That's right.
Okay.
That's right.
Okay. Based on whatever you.
That's right.
Okay. Now let's go back to where we were. You got them. You say you got them downstairs now. You already got your 18 folks.
Pull 18 at random. Take them down to the county commission room.
Okay. And what happens then?
And then I go in. The DA goes in. He's talking to them, welcoming them. I come in and I do what's called charging the grand jury, and that's where I read to them the law about what a grand jury does, and how many votes it takes to indict somebody, what they're supposed to do if people step aside because they have a conflict in the case. And I explain to them things like, if you're related by blood or marriage to the person accused or the victim, then you should step aside.
Do they have to, Judge? Do they have to? If my second cousin is a victim or the accused, and you explain that to me, is there a law that says, well, yeah, you got to go?
If you're related by blood or marriage, you should step aside.
Should, now you're using the word should though, Judge.
That's right.
What I'm trying to say.
And the reason I'm saying should is because it depends on what degree of kinship you are.
Okay.
How close kin you are.
Okay.
But the overriding principle of grand jury work is if you're related by blood or marriage, or if you're so close to by friendship, by marriage, whatever, to the person accused or the victim, and if that relationship could affect your ability to be fair and impartial, then you should step aside. And I explain to every grand jury that they should err on the side of caution. Step aside. If somebody from the outside looking in would think that your impartiality is being questioned or is in compromise, then you should step aside.
But now, the scene elementary to you. The scene elementary to you. But you assuming that everybody's a reasonable thinking person.
Well, and that's why, and I see the point you're getting at.
Yeah.
What if somebody's not? What if somebody's hiding on there or wants to be on there? And that by and large is taken care of by the number. So if you have 18 grand jurors, you have to have 13 votes, or you have to have 12 votes to present well, it's not a conviction.
Okay.
It's when the grand jury decides a case, all they're deciding is that they believe that a crime has been committed, and that a certain person probably committed it, or that there was enough probable cause to believe that the case should then come back up to my court for a jury trial.
And therein lies the basic problem. Therein lies the basic problem. Now let me ask you this.
Well,
this.
by problem you mean that the grand jury generally is only hearing one side.
Right,
of the case,
right,
and
right.
that is the prosecution side,
right.
and that's true.
And so that's where I was getting at.
And that's how the system was set up
years ago,
200 years ago.
So it's only. Are you in there when the DA is talking to the jury?
No.
Or you're not in there?
I instruct the grand jury and be sure they understand what their job is, and then I leave. You know, I'm not in there with the grand jury. Now, I do explain to them that the DA is there to present the cases and to give them legal advice. But even when they vote, he has to leave the room. So nobody's in there when the grand jury votes on whether to or not to indict somebody.
Now, Judge, help me understand, what does that mean if the grand jury does not indict, or if they indict? You said, and I remember the day when I couldn't be. But look, what does it? Does it mean anything? Does it mean anything? Let me tell you the example I always use. Okay, somebody steal my camera. I know who steal my camera. All right. So the DA got to go back there and convince the grand jury that you stole my camera, and all the evidence is that you stole my camera. And so if the grand jury does not
if they don't indict,
what do that mean? That means that you didn't convince them that I stole my camera?
Or it may mean that they think more work needs to be done on the case, or it may mean that they think that you know, there was a reason, like I stole your camera because I owned it first or something. You know, there are a lot of things the grand jury considers when they decide to indict or not indict. I'm not privileged to that because that's not my job.
You're going to have to hear it when it comes out of there.
Now, if they decide to indict, then the case comes back up to circuit court for a jury trial, and that's where, you know, we would then strike a jury for that particular case, where the defendant would be able to question the panel about, you know, their beliefs on certain issues.
Okay, let's back up. You instruct the jurors of, this is your job, this is what I want you to do, blah, blah, blah. The grand jury. You leave, and it's just the DA down there talking to us.
That's right.
My lawyer not in there, just the DA, the only lawyer in there.
Not the defense lawyers, not the defendant, the district attorney, and the witnesses the district attorney decides to call. Now, the DA can decide, it's completely his discretion on what he presents and what witnesses he calls.
Okay, all right. Okay, so now that has happened, and we're up to you now.
Okay.
Now tell me this. When you sentence somebody,
Right.
When you sentence somebody, can anybody override your sentence? If you sentence me to 10 years, and I stay 2 days and I'm back home, how'd something like that happen?
Sure.
Can you explain that?
Yeah, and that's probably the most confusing thing about my job to the general public. And I get asked about this probably more than any other issue.
Okay.
Cases come to me in two ways for sentencing. One is a plea agreement has been reached between the defense and the DA's office, and they come to me with an agreement. Okay, and it has to meet certain things. It's got to be in these certain ranges.
So when the agreement is being made, you're not part of the agreement.
I can't have anything to do with
You don't know nothing about what the agreement.
No.
Look, I read in the paper where they come in Dothan, and they said that what you call it, blind plea.
A blind plea.
A blind plea, and then they come sometime when I read about it, they say, well, they have made an agreement.
Right.
But now the judge is not part of the agreement.
That's right.
It's just the defendant and the DA.
And they come to the court and say, here's our agreement. Will you approve this agreement? Okay. Now, a blind plea is where they've been negotiating and they can't reach an agreement. But the defendant does not want a trial. He wants to throw himself on the mercy of the court, or herself on the mercy, and ask for a blind plea, which means I'm going to plead guilty and I'm going to leave the sentence up to the judge.
Okay.
Now, I don't have very many blind pleas. You know, I've had them in the past, but that's usually cases are worked out through plea bargains between the state and the defendant. And then as long as those plea bargains meet certain criteria, then it comes to me for a sentencing within those pre-negotiated
Okay,
areas.
now but you're not obligated. If me and the DA said, okay, what I'm gonna do, this is the deal. You plead guilty, but you ain't got to go to jail. You pay X amount of dollars.
Well, now that's
Then
That's
do
too
that bind you? Do that bind you?
no.
First of all,
But if I say, Reverend Green, y'all have reached this plea agreement, but say it doesn't conform to the sentencing guidelines,
okay.
and I say I can't go forward with that, then the defendant can still, he doesn't lose any rights. He can still go to a blind plea, he can go to a jury determination, or he can go back and renegotiate. That's completely within the defendant's decision.
Okay, so now you got, now you just said something there. So you're not sitting up there making all of this. You got guidelines that you have to follow in your sentencing.
That's right.
So if the DA want to give me a sweet deal, but that does not fall within your guidelines, and he can't give me that sweet deal, is that what you're saying?
He can do it, and he can say, Judge, I want to deviate above or below the guidelines for these reasons. And there are a lot of reasons that the DA may want to argue to go above them, and he would put on what is called aggravating circumstances, or he may want to deviate below them and say, well, this person was cooperative with law enforcement, and we want to, honor that cooperation with this kind of plea agreement. And I have to take all those things into consideration, and I also have to take into consideration, are there things less than incarceration that I want to try to use, like a plea into drug court, or pretrial diversion, or court referral, or community corrections. We have a lot of programs now that we didn't have even 10 years ago to try to help alleviate overcrowding in the prison system.
So now tell us again, because I threw too many questions at you at one time, but I really want to know about who overrides you when you sentence somebody.
The first misconception is that my sentence, that a 10-year sentence means 10 years, because it doesn't. A 10-year sentence, when Department of Corrections gets that sentence, they start looking at what are alternatives or ways to let that defendant release as early as possible, especially if they're a nonviolent offender. Because of the overcrowding situation.
Now, who's looking at this?
That's looked at by Department of Corrections. It's looked at by Pardons and Parole. And sometimes the Pardons and Parole Board will send back to me, you sentenced 8 years ago a person to a 10-year sentence, and they've been a model prisoner. Would you consider splitting that sentence and letting them out? And we do that.
Based on their recommendation?
Well, on their recommendation, on the family or somebody going to the DA's office and saying, would y'all reconsider this? Look at all these programs they've done. Is there a way to reduce their sentence? And that's done all the time.
Okay, but now, this is what I want to say. But it still comes back to you.
It comes back to me for any kind of amendment of a sentence, if it originally was a sentence that is eligible to be amended. That means a split sentence. So if the sentence was 20 years split 3 years to serve, I keep jurisdiction of that sentence. And that's why I like the split sentences, because then I can go in and reward somebody for doing what we ask them to do, a drug program in prison, or they've been on work release and done well with that. I believe that should be rewarded.
That opens the door for a lot of unfair criticism.
Sure.
That opens the door for. We living in the real world, and people say all kind of stuff.
Right.
And one of the biggest things that's being said, a drug dealer get 10 years, and 2 days later he's on the street.
Right.
And they say, well, the judge, getting paid off or made some kind of deal or something like that. But as much much more folks involved in that.
That's right. That's right. And you know, a lot of times those cases are negotiated up front between the DA's office and the defense about how much time they're actually going to serve. The DA has done a lot of sentences where they would serve 6 months in a county jail, and you know, because of health reasons, things like that, they're released early. Those are you have to look at every case on an individual basis, and that's the general public doesn't understand. Right. You know, Department of Corrections is always looking for reasons to let people out because of the overcrowding situation.
And you would think different. You wouldn't think that the Department of Correction are the ones who really are initiating. You know what I'm saying?
Well, it's because of the budgets, Reverend. You know, it's costing so much money that they're having to decide: do we want to spend our prison bed space on non-violent or violent offenders? And that's a no-brainer. You have to put the violent offenders in first.
Now you said something about guidelines, and I'm gonna try to wrap up here. There's so much to talk about. We can be here all day, but I appreciate your time. Well, look, you say guidelines,
right?
Okay, where do the guidelines from sentencing come from?
Well, we came up, I guess, 6 or 8 years ago with trying to make uniform sentences so that somebody in Pike County didn't get a 20-year sentence for something that somebody in Barber County got a 2-year sentence from. And so when we started looking statewide, we saw higher sentences in some places than others. And in an effort to make that more uniform, we came up with, and a lot of them came from South Carolina, which was one of the leading states in sentencing reform. And it came up with a guideline system where you, into a formula, you place the defendant's priors, you know, their other convictions or juvenile adjudications, those kind of things, and you did a worksheet that came up with a score, and then gave you a sentencing range for a straight sentence and for a split sentence. And what we do now is we sentence within those guidelines if the crime is one that fits in the guidelines.
Okay, let's go back to what I'm trying to see. Now, when we sat down, somebody had to sit down and do the guidelines.
That's right.
I want to know, was it lawyer, was it judges, was it common everyday folks? Do you have an idea?
You mean that came up with the sentencing guidelines?
That came up with sentencing. Somebody had to sit down and say, okay,
it was done,
let's present this to a.
It was done by the Alabama Sentencing Commission, headed up by some really smart people that tried to, in an effort to reduce prison overcrowding, to reduce long sentences for nonviolent offenders, with an effort toward righting some of the wrongs created by back in the Reagan administration when the crime bill and all was passed, trying to reduce some of the effect of that, because what you've had over the time since the war on drugs and all is an over-incarceration of certain offenses that were minor. And, you know,
when you look at these guidelines, in general, I'm sure there's so many of them. Which ones would you say, man, I wish we wouldn't have this one, and which ones you say, oh yeah, that's good?
And this is where the DA and I kind of disagree over some. You know, I think that the guidelines do work in that it makes the punishment of a crime pretty much uniform across the state. There's no way I could justify logically that somebody got a higher sentence because they were in a certain county. It should not be that way. It should be fairly consistent no matter where you're arrested for the same crime, the same background. You know, you have to take all those things into consideration, but within that range, the sentences...
Is that nationwide or just Alabama?
Just in Alabama.
Just in Alabama.
Now there.
So we can do a crime in Alabama, get one sentence, and do the same crime in Louisiana, and get a different sentence?
A perfect example is Florida has the 3 strikes you're outlaw. You know, which is, in my opinion, a terrible law when it applies to nonviolent offenders. You know, if you've got 2 minor offenses and then 1 major one in Florida, you're gone forever. And you know, and that does not seem to be the right thing. You know, the other problem with the way sentencing works is because of how it affects your record. And this is what our young people really have to think about. You know and I know what a felony means on your record. It means that you're never going to get a good job. You're never going to get adequate housing. And those things. And we've got to start
Can't go to
teaching,
school.
We've got to start teaching our young people how serious that felony is on their record, so that we can change the way we're thinking about that, because it does affect the rest of their life.
Speaking of Florida, here in Alabama, do we have a stand your ground law? And how does that work?
We do, and you know, most people don't understand in Alabama, ours follows and tracks Florida's. And there have been some cases under stand your ground in Alabama that juries have decided. In Alabama, it's kind of a split decision. The judge has to make an early determination about whether or not this is a stand your ground case in defense. And since it's been in Alabama, I've had 1 hearing on that. That's the only time it's ever been used.
Give me a layman's example of stand your ground. Can you do that?
Well, by and large, it means that if you're on your own property, you know, you don't have a duty to retreat. And it used to be it was confined to your own property, and stand your ground expanded that in Alabama. And you know, I have significant opinions about that, but I can't talk about it because I have to follow the law. Even the laws I don't agree with. You know, I have to follow.
Now tell about this law. And some people say it's new, some say it ain't new. This carry law, this open carry law. I read in the paper all the time where people get stopped for something, they get arrested, and one of the charges would be having a weapon. They don't say concealed, they say having a weapon. My understanding of the law is, as long as my weapon can be seen, that I can carry my weapon anywhere that does not have a sign say no weapons. Is that the law?
I think generally that's the law now. Now, you know, that's relatively new. You know, we had the law of concealment and pistol permits and those things. And yeah, you know, my recommendation is always to have a permit and always to have, you know, your weapon registered. But you know, you certainly have the right to have a weapon for your personal protection.
So now the law. Now you said something, and the trick is now the law says, correct me if I'm wrong, that the weapon, you don't have to have a permit, and your weapon don't have to be registered as long as it's open. Is that correct?
I think that is correct.
But to be safe, you say get your permit and get your register. We ain't got to worry about no harassment.
The better practice is to do that, and you know, it's safer for you, it's safer for law enforcement, it's safer for everybody. Now, you know, what's the recent thing has come about businesses that say they've posted weapons on the premises, and you know, certainly that applies to public buildings and those kind of things. But you know, in light of recent happenings, school shootings, theater shootings, those things, I think that's a natural turn of events, a response to that, because people are afraid of what can happen to them in a grocery store and all.
Now, let's go in your courtroom. Let's go in your courtroom. We assume that you're the ruling authority in your courtroom, so you're the most important person in your courtroom.
I don't know about that. I have a lot of people that assist me in what I do. You know, Tracy, my judicial assistant, and my court reporter, and the clerk's offices, and the pardon and parole people. You know, they're all making recommendations in cases, and I have good people around me. You know, I can't say enough about how hard they work and how they treat each case individually.
So it's a lot of what you're saying that I hear you saying. A lot of work goes on before you even hear a case.
That's right. You know, and by the time a case gets to a jury in a criminal case, there have been a lot of hearings that have to do with specific evidence, or being sure that the defendant understands what his rights are, what her offers are, what she's looking at or he's looking at if convicted, what they're looking at under a plea agreement. You know, the one thing I can't tell them, and this is frustrating, is that if they plead and if they have to go to prison, how long they're going to actually spend.
Really?
You know, on a straight sentence, there's no way for me to tell them that. And I'm upfront with them about that. There are a lot of things that affect that within corrections that I don't have any say-so on.
Let me ask you this. I'm glad you said that. Let me ask you this. Can you, when you look at a case, and you know it's best for that person not to have a jury trial, can you recommend them not to have a jury trial?
I can't.
Can't do it.
I can say, now your options are jury or non-jury. You can plead or you can ask for a trial. But, you know, I can't make any recommendations. I can't say it would be best for you not to do this. Now sometimes, you know, in a right before trial, the defense lawyer will say, Judge, will you sit down with me and my client and, you know, talk to them? And I have to have approval from both sides to do that. So I have to say to the DA, they want me to sit in conference with them and talk to them. Now, in a capital murder case, the DA doesn't have any say-so over it. I have to do it, and I do it in every capital case. And if you think of it, that makes good sense because somebody's life's at jeopardy. So in a capital case, I'll have 10 private conferences on the record. Now, my court reporter will be in there.
But not the DA won't be in there.
The DA will not be in there.
Okay, now let me ask you this. Can you make, and we sit down in here, and my lawyer what would my lawyer be doing? Trying to make a deal? Flea bargaining? What would my lawyer be doing?
Usually it's a question and answer thing between me and the defendant. Well, I'll say to him, now, I want to be sure you understand the procedure. That's where we'll start. This is a capital case, and this is how it'll happen. Are there any questions you want to ask me? Are there any questions that you want to ask me about what your lawyers told you? You know, those are all things that we'll talk about. They may have motions in a capital case that they want to file that are called ex parte motions, which means the DA does not get to know about them. He doesn't even get to know that the motion has been filed. And that's specific to a capital murder case.
No, why would we file something and the DA not have a chance to come back and...
Well, because it may be to ask for funding for, say, an expert witness on DNA or an expert witness on fingerprint, where if the DA knew that the defense were asking for that, it might make them do their homework a little better or in that area of the case or something. And because a capital murder case is different and treated differently from the very beginning on, those things are allowed in a capital case and they wouldn't be in another case.
Let me give you an example about asking for the DA to be removed. In Ferguson, the case that we've been following in the news, they said that the DA is so biased that they don't want the DA to be the one that prosecutes. Can we come to you? Could we come to you? The lawyer come to you and say, listen, this family has been having a run-in with this DA family for years and years and years. We think you're going to be biased.
I've never had that question come up before, Reverend, but I suppose it could if they could show some kind of personal bias or a vendetta or something like that. Then I guess that could come up. I've never had it. I've never had it come up.
But you would be the one that we'd have to bring it to. See what they're doing in Ferguson? They're going to the governor to try to get the governor to take the DA off.
Well, Ferguson is a little more complicated in that you've got state court charges and federal court charges, and Attorney General Holder before his retirement was handling the federal side of that case. And you know, in a case like Ferguson, it can be pursued either in federal court or state court or both. And that's why, like, in sometimes, like in Rodney King years ago, you saw where there was an acquittal in state court, but a conviction in the federal court.
Look, okay, now, I think, and I'm going back to my question, because I think it's very realistic. We living in a town like Eufaula. Eufaula is one of the biggest towns in the world. And everybody just about know everybody, and every family know every family. So there is a possibility that my family could have had a run-in with the DA's family over the years.
Well, that's right. And you know.
So where would I go? Where would I go if I got in trouble? And I perceive now that the DA has a bias, where would I go? Who could I plead my case?
Well, I suppose that you would start with filing something with the circuit court saying, you know, I'd like a special prosecutor or something like that.
And that's you?
That's me.
Okay.
Which would be asking for a special prosecutor to be appointed. And, you know, sometimes I've seen the DA step aside in cases where it would involve persons that he had other cases with and things, where he would ask for a special prosecutor to be sent in to handle that case because he had a conflict. Now you're asking the opposite side of that. Could a defendant ask for removal? And I've never had that come up, but I think they could. You know, we'd have to have hearings on it to see what the reasons are.
Now when the DA step aside, is that his whole office or just him personally?
Well, it depends.
We got a male DA, that's why I keep saying he.
Yeah.
You know.
Well, it depends. Like I have a case right now where the Office of Prosecution Services is handling the case because the DA stepped aside, and they handle it all from Montgomery.
Okay.
I have some cases in other counties where the judges and the DAs have had to step aside, and I have to go in there and hear those cases. And usually I have the Attorney General or the Attorney General's office handling those.
Now, let me ask you this, Jared. We know they're just very hypothetical, very hypothetical, almost in the range of impossibility. What happened if you got in trouble?
Well, you know,
You're the secretary.
I have to recuse from cases all the time. I recuse in cases where I think my impartiality could be questioned. You know, early in my career as a judge, say I had a former client that had a new case. Well, you know, I would talk to the lawyers about it and would say, you know, if either side wants me to step down from the case, I will, and we'll get Montgomery to send in somebody to hear it. I still have those today.
What about if you got in trouble?
Got in? What do you mean got in trouble? Like if I got accused of a crime.
Right. Let's say you went to the country club. Okay. Well, that's why I say very hypothetical.
Right.
And remember, impossibility.
Right.
But on the way home, on the way to Union Spring, between here and Union Spring,
I got a DUI or something.
Right.
Yeah.
What happens?
And that's called disqualification. You know, if I'm accused of something, of course I couldn't hear my own case. It's like if my wife files a case on behalf of one of her clients, I can't hear that case. That's called disqualification. Now, recusal is something where I have a connection with it or perceived connection with it that might call into question my ability to be fair and impartial. I have some divorce cases, you know, because we're in a small town, especially over in Union Springs, where I know both sides. And generally what I do is I sit the parties and their lawyers down and I say, you know, I know A and B and I've known them for years, and if either side wants me to step aside, let's talk about it right now. And if I step aside, then the procedure is I ask the district judges if they can hear it, and if they can't hear it, then we'll ask Montgomery to send in a visiting judge.
Let's go back to your DUI. You can't hear your own case.
Now I don't have a DUI.
Very hypothetical.
Right.
But what I'm saying, somebody in your position, let's say it like that, who would hear that case?
Then Montgomery, the Alabama Supreme Court,
that's what I'm
send in a judge to hear that, and that has happened. You know, it's happened all over the state. In cases where the judge is accused of doing something wrong, then the Supreme Court would then send somebody in. Most of the time, though, it happens in conflict cases. I go most Fridays, Reverend Green, to other counties and hear cases where judges have stepped aside because of disqualification or recusal, or like those files sitting over there on my desk, those are death penalty reviews that I'll go in and do because another DA and judge heard the case, and I'll go in and start from the very beginning and hear everything again to decide whether or not the lawyers were effective for the defendant and whether there were mistakes made before it goes up.
Now, when you say you hear everything just on paper, or you actually bring people in?
Oh, I bring people in. Like those are two that will start next month, and they'll take, you know, 4 or 5 days of of testimony and argument, and that's a special thing because those are capital murder cases.
Oh man, this is very interesting, and one of the things I always promise my listeners from day one in Gumbo Live is that my program would be very informative and very entertaining, and we were very informed today. And
well, I hope I answered your question
the
best I could.
Well, yeah, and I think you did, and I really appreciate your honesty, and I really appreciate the opportunity to do this interview.
Well, one thing I want to say, rather
sure,
than
please,
we talk about this,
whatever you want to say.
You know, my door is open, and that's one of the things I ran on 18 years ago is accessibility.
Mm-hmm.
But I have to make sure that everybody understands there's certain things that I can't talk to you about.
Mm-hmm.
A specific case, you know, I can't talk to you about. Now, if it's a case that's over, and say it had to do with your daughter or your son, then as long as they and their lawyers agree to it, then I could talk to you about it to explain why they're still there or when they might get out, those kind of things. And I do that all the time. That's probably what I spend as much time on as anything is meeting with families because their loved ones locked up somewhere or in a divorce or something. But I have to explain to them if it's something that's pending or something that could come back up before me, I can't talk about it.
I'm gonna say this before we wrap up. My friend Judge Charles Price is gonna be watching this, and he's the J.F. Kennedy Profile and Courage winner, and I'm sure you know him.
Absolutely.
But in many of
he's the judge when I have questions that I don't
that you
know,
call.
That's who I call.
God bless him.
Because Judge Price has been doing it.
Sure.
On the front lines and at a higher, you know, his caseload is unbelievable.
Really?
Because a Montgomery Circuit judge hears all of the state cases also.
Oh, I didn't know that.
So if a state agency is sued or a state agency has a claim, those have to go to the Montgomery County judges.
Well, one of the things that I always talk to him about, and I'm always amazed, he's like you. He's very accessible.
Oh, absolutely.
And I've had him everywhere I've ever pastored. I've had him come, normally in February during Black History Month or Martin Luther King in January. But he's always just him, maybe just him and his pastor, him or nobody, you know.
Right.
And I was always amazed at that, sitting in the position that you sit in. You're concerned about your personal safety or your family's safety.
You know, sometimes there's situations where you get more concerned about your family's safety. Of course, with Judge Price's position, you know, he's a former Green Beret.
Yeah.
I don't think he might have, probably wouldn't want to mess with Judge Price. You know, you do have to have those concerns, especially in you know, in our society today where mental health issues are so bad. And what I've always tried to do is be as fair and impartial and kind to people as I possibly could. It's never been a situation where I liked sending somebody off. It's one of those things. It's my job. I try to do it as fairly and impartially as possible. I understand that people don't agree with some of the decisions I make. I say to community groups and all the time, every time I make a decision, one party or the other leaves mad. That's generally true. But I try to do it, and I try to be able to look somebody in the eye and explain why I did what I did.
Can you ask for, and where would it come from? Let me give you an example. I didn't know where you live.
Right.
One day I was in Union Spring. This fellow, me and somebody else was in Union Spring.
Right.
He said, "I'm gonna share where Jerry Smithhart live," and there's more security at Elvis Presley house than got at your house.
Well, that's because Elvis is a lot more important than even dead. He's more important than me.
At Graceland, I remember going by Graceland and they got this big old. But where would it come from? And could you ask for personal protection?
Well, there are times when we have to have more security than others, and I can't go into really why that is or where.
Sure.
But I've always had a listed phone number. You know, in a small town, and you follow in Union Springs, Clayton, Louisville, Clio, Midway, all those places, people know me, and I never tried to avoid people. You know, when I go to the grocery store, it's an hour trip at least,
Yeah,
because people have things they want to ask, and people are scared to come into the courtroom and come into your office, and sometimes they have just a simple question.
Right.
Sometimes it's about jury duty and things like that, and that's part of the job. When I ran for it, that's one of the things I agreed to do, and sometimes I have to tell people I can't talk about that, we can't discuss this, but if you'll get the lawyer and come to my office, we can then, and people are really nice about it. Really.
I remember talking to our sheriff, Sheriff Upshaw, and I told him, I said, Sheriff, I said, one of the complaints, people say they don't see you. So he told me, he said, meet me at Walmart.
Well,
he was at Walmart trying to shop.
Yeah.
You know, and something that would have been 15 minutes ended up being hours and hours at a time. And I left him there as a sheriff. I'm going, I see your point, you know.
That's part of it.
Yeah.
That's what you ran and agreed to do. And so that's part of the job. You know, if you get to the point where the public doesn't see you and the public doesn't feel like they can call on you and talk to you, then, you know, your position is compromised.
Okay. But no, whatever you do, sir, don't never compromise your safety or the safety of your family. Please don't do that. We want you to serve for a long time, and
well, I appreciate it.
And we wouldn't want nothing to happen to you. And I hope that your kindness don't block out your.
Well, I hope
your reasoning. You know what I'm saying? Sometimes you get so kind that it blocks off all sense of reasoning sometimes. But now, is anything that you tell our audience what you like most about the job, and probably sensing is what you like least. But I'm not gonna put that in your mouth. Tell what you like most.
I like most.
Okay.
Now, I get to deal with people, and I try to remember every day that when they're here, it's not because they want to be.
Yeah.
They're being told, whether it's a civil suit or a criminal case or a domestic case, it's the most important thing in their life right then. And they're not here because they want to. They're not trying to waste my time. They're here because they need somebody to help them get something resolved. And I like that part of my job. The least favorite part is sometimes in domestic cases where you have two really good parents that love their child, but they can't stay together. I have to decide where that child's going to spend most of their time, and that's a hard decision. You know, that's something that weighs on me and something that takes a lot of prayer to decide.
Is there guidelines for that also? Like you say, you have
there are, but the hardest cases are those where both are good parents, both are doing a great job, both just love their child, and they want to spend as much time as possible with their child. And that's just a tough decision. That's probably, you know, it's probably the hardest decision I have to make. You know, in a criminal case, when I have to decide what sentence to impose, there are guidelines and formulas and recommendations.
Right.
And in domestic cases, with two good parents and a good child, those are the things that keep you up at night.
You know, it was always believed that the woman automatically got the child, but that ain't necessarily so.
That really has changed, and it has changed in the 18 years I've been on the bench, Reverend. Society and the way men are looked at in divorce now has changed, and it's changed for the better. You know, we've got now where I'm by statute supposed to look at trying to do joint custody in every case I possibly can. Now, you know, one or the other parent usually has to have primary physical custody. That means where the child actually is going to live during the school year. But you know, when I first took the bench, 90% of all child custody cases, probably 100% when they were under 2, went to the female.
Yeah.
And that's something. The law's always changing, and society's always changing. Sometimes for the worse, but sometimes for the better.
Well, I as a citizen of Eufaula I want to thank you for the way you conduct yourself, not only in the courtroom, but in the general public.
Well, I appreciate it.
And I appreciate your accessibility.
Well, thank you.
We want to thank your family for we know that she has to support it. She has to support you.
A great wife.
Yeah.
And she's right by my side, you know, in all the things that we do and we go to. And we made this decision together a long time ago, and we made this decision because I felt like I was being called to do it.
If you wasn't a lawyer in the jury, what would be your
Football coach.
Is that right? All right. I see it in you. I see it in you. But listen. I want to again. I want to thank you for being my guest, and I'll be knocking on your door again.
You come see me anytime. And,
I want to tell my listeners we're gonna break this down into 2 segments. We're gonna break it down into 2 segments, and the first one will be on tomorrow night at 6:45, and it's gonna be on YouTube also.
Okay.
So, because
you
can't get it in Eufaula, in Union Springs. But I made sure I talked to my production crew, and it will be on. It may be on YouTube tonight if I get it to them in time.
Well, anytime you need me for something, just let me know.
And I know that, and I appreciate that, and not only me. That I'm not getting any special treatment, but anybody out there in my listening audience, you can talk to this man. You got to respect his position and respect what he can and cannot talk about. But you can talk to this man.
That's right.
You can talk to this man.
And if you need me, Tracy in my office, she can track me down. I'm on the road a lot, but Tracy can get me, and I'll return your phone calls. That's what I do in my spare time.
And I want to say on that camera, Miss Tracy, thank you, because she made this possible.
That's right.
And thank you, Miss Tracy, for all that you do. But look, we want to keep Miss Adrian down. But I can assure you she's in good hands over in Texas.
She is. And Tracy talked to her this morning. She's in great spirits.
Good,
they've arrived and checked in, and she's going to keep us posted.
Good.
Thank you for bringing that up.
Yeah, oh yes, sir. We ask all of our waters to keep her in prayers. Again, you've been watching Gumbo Live. We are right here. We're not in our regular office, but we're in a more beautiful office. I'm gonna try to see if I can't do more filming in here.
All right. Anytime.
Thank you, sir. Thank you so much. You've been watching Gumbo Live. Thank you.
The next time you need a haircut, think of the barber shop with a grand tradition. Williams Barbershop. Williams Barbershop, proud to serve the entire community of Eufaula. Come by to our new location, new facilities, and see what it's like to be treated in style at Williams Barbershop in the old JCPenney catalog store. There is another choice for making funeral arrangements. Central Funeral Services, located in Eufaula and Louisville, Alabama. With one-of-a-kind staff, thrives on professionalism and meeting the unique needs of families with a wide variety of services. Owned and operated by the Mixon family. Call 687-1060 or 266-5261. Melissa Mixon Smith, licensed funeral director.